A very good morning to you all, and thank you very much for tuning to 93.3 KFM. This is VPN, that is Views, People and News. I'm your host, Judith Atim. Today we are talking about the justice sector, and we are asking ourselves, how can the judiciary be positioned for a just society? My guest this morning, I have with me Ms. Mercy Grace Munduru, who is a governance expert. She's also the head of programs at Action Aid International Uganda. Good morning, Mercy.
Good morning, Gigi.
Looking so good.
Very well. This struggle shall not be one.
Guys, you should see what Mercy looks like. She looks like a real Musama. She's a true diva in the studio here. And I'm also pleased to be hosting Counsel George Musisi, human rights lawyer. He's also partner at Pace Advocates. Counsel, good morning and welcome. Looking dapper in your suit.
Good morning, Judith. Good morning,
You will
Mercy.
just know he's a lawyer.
Even on a Saturday,
Yeah,
to be in
I would never pass for a lawyer.
Mercy is trying to deflect the Musama look. She wants to just give us dollars at the end of the show. So.
I'm confusing the enemy.
So, guys, it's been a very, very busy week, no doubt. Just a few issues that I want us to just take you through. Let me just look at what the week has been like, some of the highlights. We had the 7th Benedicto Chiwaneka Memorial Lecture yesterday at the Courts of Judiciary premises. It was attended by officers of the court, officials from the different arms of government, and the Chief Justice. The Speaker of Parliament, Anita Mong, represented the President as the chief guest. The Chief Justice, Alfonso Windolo, called for strengthening cooperation amongst the three arms of government, respect for the judiciary, and the protection of its independence. He said meetings with the president should not be misinterpreted as collusion or intimidation. The Speaker of Parliament, Anita Mong, asked the judiciary and the executive to join Parliament in fighting for the protection of Uganda's integrity. And on Tuesday this week, Parliament also resumed plenary sittings. There was a motion to pay tributes and honor the late Rebecca Cheptegei, our athlete who was a victim of gender-based violence. The motion was adopted unanimously. And in that sitting, we saw one of the legislators actually narrating bravely how she's also facing having some bad experiences in her own family related to GBV. The House also focused on other issues like the affairs in Uganda's education and other sectors. We've also seen the contest for the presidency of the Uganda Law Society get heated. A series of candidates' debates for the race to the next ULS leadership took place ahead of next Saturday's polls. 3 candidates are vying for the top office. They're hoping to replace Bernard Owundo. And further afield, far from Uganda, on Wednesday, Israel carried out an attack on the suburbs of Lebanon's capital, Beirut. 14 people at least were killed, including Ibrahim Akil, who is the operations commander of Hezbollah, a paramilitary group. This is Israel's 3rd major attack on Beirut since the beginning of 2024. The attacks have continued since Wednesday, with Israel saying they will attack other areas in pursuit of the enemy to protect its citizens, and the UN is now warning that the region is on the brink of a major catastrophe. Very packed week. Stephen has just shared with me something that it has emerged that the Justice and Constitutional Affairs Minister, Norbert Mao, is set to introduce before Cabinet his proposed electoral and political reforms. That has been the talk also of the week before they are adopted as the executive position to be tabled before Parliament. And guys, I don't know if you've been seeing how X is busy this morning, especially the Twitter handle of Muhoozi Kainerugaba, the Chief of Defense Forces, who is also the first son. He has announced he will not be on the ballot paper in 2026. In his words, Almighty God told me to focus on his army first. So I fully endorse President Yoweri Museveni in the next elections. Then there were these other tweets. I think I took some screenshots of this. What is it that he said? No civilian will lead Uganda after President Museveni. He says the security forces will not allow it. The next leader will be a soldier or policeman. And basically, I think for me, those are the biggest that captured my attention. So, Mercy and Counsel Musisi, let's take your quick reactions to these issues. before we delve into our topic, which is about positioning the judiciary for a just society. Which one do you want to react to first?
Well, first of all, the tweets themselves, they would be taken for jokes if they're not coming from a person holding a high office, because we've seen a number of hilarious tweets coming off that handle. But maybe they're just giving us a sense of the thinking of the mind, because ordinarily, General Muhoozi wouldn't even be talking about politics. Ordinarily, wouldn't be tweeting about who should be Uganda's president. Very many people, including generals, have been court-martialed for much less than what General Tumukunde spent almost 10 years on trial over doing something. He was even a member of parliament, but you have a serving soldier, CDF, talking about politics, talking about who should be president after his father, talking about how he's even going to, ordinarily wouldn't even be mooted as a candidate because he's still a serving soldier. But it shows you the impunity with which he's going about his business, that the law, both the Constitution and the UPDF Act, they don't concern him by virtue of his ancestry. And I know that there is not any other UPDF soldier who can say what he's saying and go with it. It shows you the work that we have in the country, that when people talk about state capture, it's exactly that the president's son is above the law. Basically, that is what he's saying, by virtue of being his father's son. So for me, it's not news. It's not surprising, because he has done much worse. But it goes back to this whole issue of the pretentious nature of that our democracy, which we are trying so much, issues of the rule of law, that maybe these people, the leadership, only believes in it only when it suits it, only believes in the law only when it suits them. And as you can clearly say, General Muhoozi knows he can go with anything, and because he is above the law. Basically, that's what they are trying to front. That's why he's patron of a political organization. He has done campaigns openly. He's now talking about succession. He's talking about, of course, succeeding his father, and then who should be president. That is not a duty of his family. It's a duty of Ugandans to choose who should be president. But of course, he's certainly above the law. That's what they're telling you.
Mercy, your thoughts? Pick any of the issues that I raised and just react, whether you want to respond to the CDF's comments on X or any other.
Yeah, so maybe starting with that, because the only ones I feel sorry for are those who actually believe that we're very serious about the rule of law and democracy. Those are the ones I feel sorry for, and I do hope that having seen those tweets, we fully understand and comprehend the fact that we are a pseudo-democracy. And those are my personal views. Why? Because Council has just described the selective application of the law, and us bending over the very laws that we committed to uphold, and we have even invested in systems and structures to uphold these laws, yet we blatantly go against them, and then we turn around and choose to use democracy as and when it serves us. But also, it really these are not far-fetched tweets. These are not mistakes. Sometimes people make jokes about it and say they are made when somebody is drunk. They will say these tweets are made when probably they're just joking, or that it's an act of play. But like Council said, coming from a person who holds a position, especially in a sensitive agency like the military, should be concerning for us as citizens. And because the well-being of this country, the governance infrastructure of this country, is built around our own aspirations. And if there's a threat to how we are governed, we ultimately pay the price. And so we need not to look at these things selectively, and we need not to take them for granted. We need to know that there's a message in there. If the message is that Uganda is not operating within the rule of law, believe it, because the people who are supposed to uphold, who are supposed to protect us citizens, are saying that, and so we believe that. On the other hand, I think it's been quite interesting seeing Ugandans exercise interest in the leadership of Uganda Law Society. It's been rather interesting. I was personally, as a lawyer, I've been on the sidelines watching the contest, but also it speaks to how desperately Ugandans are looking for alternative leadership. Anything that presents itself as representing their views, understanding their issues is enough for citizens to rally around you. And I think seeing non-lawyers engage more with this electoral process is very telling of how desperate our people are for alternative leadership. And when this happens, that means there's a deficit in the formal structures of leadership in this country. And so people are looking for those who look like them, act like them, speak like them, and ultimately represent their views. But of course, that also says something about the Law Society itself. We do not know if the members share their aspirations. I believe that as lawyers we are at crossroads because part of the call is to represent the interests of the legal profession, but also part of it is to represent the views and opinions of Ugandans, to be the bridge. And so in picking a leader, we have to think about a leader who represents both, knows that there is the legal profession whose interests must be protected and that there's a legal mandate in the law, but at the same time that the leadership should be representative of the diversity of Ugandan citizens, their opinions and their interests, and that at all times Ugandans should also have confidence in the leadership of the Uganda Law Society as mandated under the law.
Thank you. Your thoughts on ULS? You guys are voting, right? 28th?
Yeah, next week. There's been a lot of, like Masa said, attention. If you go on Twitter, actually, there's more debate between non-lawyers than even from the lawyers, which for me I find healthy. I have no problem with it because of the unique nature of the Uganda Law Society and the unique mandate. And actually, there are many people who have felt that over the years, the way in which the Uganda Law Society has stamped its authority on rule of law issues in the country, because that's one of its fundamental obligations. I remember some years ago, I think 2017, when there was an attempt to, and later they amended the constitution, there was debate in an extraordinary general meeting of the Law Society whether ULS should have a position on amendments. And there are some lawyers, of course, who are saying, no, we shouldn't have a position because we have different parties and interests. And I remember, I think it was Professor Sempewa who asked that if lawyers don't speak out on a constitutional amendment, then who should?
Exactly.
Should it be the Medical Association, the surveyors,
as the journalists,
or pharmacists? So the debate is healthy. The national interest, I think, is healthy. Of course, there are three candidates vying, or three of all of whom I know at a personal level, and I can only hope that lawyers come up to, and whoever wins, I hope that they can take it a notch further to stamp the authority. I know it's also important to note that the person elected will be president towards the electoral season. The last election season went through a lot of issues on rule of law issues. I suspect our most fundamental rights, which we are guaranteed in the Constitution, were most tested. We saw trials without detentions without trial. We saw extrajudicial killings on the streets of Kampala. We have missing persons up to date from the last election. So I see no reason to think that there will be a change in the next. So I think it's critical for lawyers to know that, or whoever should be elected, that there is a strong test on issues of the rule of law. Master was saying that he feels sorry for those people who believe in
rule of law.
and I'm one of those was fundamental believers in the rule of law amidst even all the challenges and problems we see, and that's why we should vehemently resist this kind of attempts, like even the preacher talking about, where people wantonly abuse the law with disregard.
Okay, thank you. So basically, in essence, what ULS needs is a leader with a thick skin, someone who can put his or her foot down and say,
especially to put
and balance the interest
and put the position of ULS where it should be.
Interesting. So actually, that is one of the issues that has actually informed our conversation this morning about the justice sector and how to position the judiciary as for a just society. So when you look at issues, of course, if you've been following the NUP detainees who are actually in the court-martial, and commentaries that we read about them being forced to go into plea bargain, and some are now opting to out of desperation because of the long detentions, all the psychological trauma and torture that they've gone through over the years. Just from a legal standpoint, if you could just help me understand, how do you make sense of this, actually, in legally speaking?
Of course, we have a fundamental problem of access to justice in this country. And I know that despite the different solutions, like, for instance, the current judiciary administration has tried to put in place more courts, more, there's still a big problem of disposal of, even at a very basic level, even if it was to be a case between me and Judith, a civil case, I sue you for trespass in land matters, it might take an average of 3 to 4 years, or 5 years. Some of them can take even more than that. And of course, at the very basic level, you ask, even if I emerge a victor out of this, even if they declare me as a lawful owner, after 6 years, is it worth it? So every person, it's even worse if you're dealing with criminal issues, where there's an issue in our laws. I know that sometimes we challenge this in the Constitutional Court and it's said to be determined, what they call pre-trial detention. If you are charged with a serious offense like murder, you can even take up to 3 to 4, 5 years in detention before trial, when they commit you. And of course, many people, when we highlight this case of the NUP suspects, as the supporters, the only difference is that, one, for them their case is outrightly political, and of course they're being tried in a forum which we believe they shouldn't be tried in. But actually there are many other detainees from courts of judicature who are facing maybe a murder, who are facing terrorism, who have spent 3 to 4 to 5 years in detention without trial.
Pre-trial.
Yes, in pre-trial. The moment you're committed to the High Court, they say you'll be tried at the next convenient session of the High Court. It can come
very ambiguous.
It can come up with. So there are still serious challenges regarding that. And of course, the biggest problem it sends is, one, if you're innocent, you'll either serve a sentence before conviction of 5 years. The moment you're brought to the High Court for you to be acquitted, you'll go away, 5 years of your life wasted. In fact, even in these courts of judicature, the people who go into plea bargaining thinking it's their best way of getting out of prison. If they tell you that, okay, if you plea bargain, you'll walk out in 2 years, the person realizes that they've spent 7 years, 6 years in pretrial detention, they think it's their best way of getting out of prison. So it's one thing that we should fundamentally work on. I know that there are still efforts, there are efforts which have been made, but they are still much less compared to what actually the need is out there.
Thank you. Let me hear from you, Grace.
Yeah, I would not want to divulge too far, but it still is interconnected with what we opened with about you cannot dissect where our governance is from how the justice system works broadly, because the judiciary and really ultimately the justice system that is vested in them exists to uphold the principles of separation of power. That means they come in between to strike that balance and give an independent positioning for things like what Council has described, that they stand firm to ensure that they are the face of fairness to those who come before it. Because we have, on one hand, the justice system, we have the law, we have the people. And the judiciary is supposed to be the bridge between these three. And so if you examine our judicial system now, we have to ask critical questions. What is the face of the judiciary and the justice system? How do people perceive the justice system? Is it the face of fairness? Does it, because every system is built around its users. And how is this system representative of the people who come to it or who have contact with it over and over again? I know that the quest for justice, especially for those who we know are unfairly enduring political persecution, has majorly been from citizens. It has been from their families. It has been from political parties that they're affiliated to. What have the other two arms of government done to ensure that they're firm in drawing the line? That despite my political affiliation, when I am serving in any of the three arms of government, I must make sure that I uphold the rule of law and that I am firm when it comes under threat. The issue of the NUP supporters, for example, as an example, has been one that has been before our face for a long time. We know that the courts have made a ruling in the past about not trying civilians in military courts, and this is on record. What does continuously having citizens appear before the military court, what does that say about even respect of the decisions of the court? What does that say? Because the court has ultimately pronounced itself on this matter before. What does the continued detention of people, not just by the NUP supporters, there's so many, if you go to the prisons, I've been there in the recent past, as a matter of fact.
I think I'm told there are people who've been there like 10 years.
10 years. So, I've been there recently, and it's
issues.
Exactly,
yes.
But also beyond that, the prisons are congested, and yet these people are not getting out of that system at all. Petty and political crimes and whatever, all bundled up there. And yet, when you look at how justice is administered on the other side, it does not take into account these realities. So for me, it is a question of what is the face of our justice system. When people look at our justice system, does it represent its aspirations? Especially without disconnecting from where we are at in terms of our governance. Because people are looking at every institution and where it is bending towards. It's not a secret that where we are at today, your political affiliation is a huge determinant. If I wanted to take up a job in government, they will do a thorough background check on me, and part of it is my political affiliation before I serve the country. And so whether or not I'm interested in this job, because I think as a lawyer I would like to be to cross over, on the other side, my political affiliation will be a determinant of whether or not I take up that job.
So it is not so much a matter of meritocracy anymore.
Exactly.
It is a reward and sanction kind of thing.
Exactly.
You're rewarded for your loyalty and punished for your disloyalty. Thank you very much, Mercy. Let's take a break, and then we'll be back and take on this discussion further. And then I'll also formally welcome our other guests who just walked in right now. Let me give him a minute to catch his breath. Welcome back from the break. This is still VPN here on 933 KFM. My name is Judith Atim. We are talking about the justice sector, and we are asking how best to position the judiciary for a just society. Let me now take the honor to introduce my other guest, His Worship James Eremie Mawanda, Public Relations Officer of the Judiciary. Your Worship, good morning.
Yes, good morning, and good morning, our listeners.
You've caught your breath now?
Absolutely.
Okay, I know our stairs can do a number on you, but I'm really happy to have you.
Thank you.
My other guest, once again, Mercy Grace Munduru, who is a governance expert, as well as the head of programs at Action Aid International Uganda, and Counsel George Musisi, human rights lawyer and partner at Pace Advocates. Guys, this is a legal discussion. Like, the panel is just legal, so there's just so much legalese that will be going on here.
Pretend I am not.
You are. Mercy is a lawyer as well, so it is an all lawyers. It's a showdown, not a showdown, but it's a conversation between lawyers. I mean, we're talking about the judiciary, so why not? We need the people who are there, who understand the sector better than we do. So, Your Worship, before we actually went into the break, we were still talking about, we started the conversation, of course, looking at issues that have been happening, including the tweets by the CDF. If you want to weigh in, you'll weigh in on that later. But the first question the first point of our discussion was about the issue of plea bargain.
Yes.
Looking at what the NUP supporters who've been detained for all these years are going through. many of them, of course, the conditions they find themselves in are forcing them to actually take plea for offenses they did not commit, perhaps, or they're not even aware of. And when we are talking about restoring justice or positioning the judiciary for a just society, like Mercy was just saying, what does justice look like for an ordinary person? If I am being forced to take plea for an offense I did not commit, is that still justice?
Well, first of all, I want to thank the guest for that observation, and I want also to thank my brother Msisi, who is always with me to try to bring these matters to knowledge. Our people definitely need a lot of sensitization about some of the things for them to be able to contribute positively in the administration of justice. Plea bargaining is one of the interventions that the judiciary has mainstreamed for purposes of case management and case backlog reduction. But one key component is the guilt or innocence of the individual. I know there are those conditions which people face in the prisons, but that has never been one of our considerations for plea bargain. Plea bargain is where a person chooses to have any offense on his own volition, believing and with a conviction in himself that he committed the offense, that comes up to enroll for plea bargain. Anyone who is innocent and who believes they are innocent is not party to this plea bargain. Now, when we hear those stories, and we have continuously sensitized inmates in prisons, including those who are outside prison, because plea bargain is not only about those who are in prison.
Any of us is a potential...
Even those on bail, have the option of plea bargaining. Now, when we hear some of those stories, we equally get surprised because we have sensitized the people. We have ensured that anyone, even when they enroll, the key checks are to understand, were you forced to enter into this plea bargain program, or there is some other underlying factors? That's why we want always to encourage our plea bargainers, their lawyers, and prosecution to ensure that we do not do injustice. This is just a case management intervention to reduce on lead times, because if a person, for instance, these small offenses, including the capital offenses, yes, but I want to use the most common cases in the lower courts. You find a person is charged with criminal trespass. All right? It's not about any claims of right over land or something. He purely was in somebody's compound, okay? And he has no defense. He's in prison, remanded, for instance. Of course, we're also addressing the issues of why should we remand people, okay? However, he is on remand, and he has pleaded not guilty by the time his case is concluded because of the volumes we have. He has spent a month, 2 months, 3 months. All right? But he, down his head, he knows he committed the offense. So that's why we ask our advocates, Mr. Msisi here, and all other service providers, legal aid service providers, let us talk to our people. And we must first of all understand, are these people really guilty of these offenses? It is the responsibility of all court officers, including advocates, to ensure that should they suspect somebody simply, apparently coerced into plea bargaining, then that information should come out. And the court should be put to notice, and the court will make an intervention. So that's plea bargaining, and it's very unfortunate if people are being forced into plea bargaining. But we have had also systems within the prisons, the continuous training there and the sensitization by prison officers. So at the end of the day, and by the way, if a person came out and talked with his lawyer and the prosecution and the plea bargain is suggested, and the court would probably at some point not know that there were those other elements. And I know. But let us empower our people. Let us engineer systems that are able to reduce such instances. And that's what we are doing in the judiciary. How are we doing it? For us, knowing that now we have those issues coming up, we are ensuring that those who come for plea bargain, they do the plea bargain, and those who actually need trials, we get the resources, we allocate sessions for the High Court, and ensure also in the lower courts these matters are handled so that there is justice. Okay?
Thank you. Thank you very much, Your Worship. So the next thing I want us to talk about are these proposed electoral and political reforms that we're seeing coming up at such a time. I think it started weeks ago with Honorable Lumu with proposals for the parliamentary amendments bill. And of course, the most contentious was LOP, having the LOP come from the broader opposition and not the party with the majority. I think we've had a series of conversations on that. But now, weeks later, we see the Minister for Justice and Constitutional Affairs also coming up with reforms, proposals. Now we are seeing, well, the conversation earlier with some circles was like, well, we are not sure whether that is a Mao the person pushing that bill, or Mao the cabinet minister, and if he's working as a cabinet minister, then he should have actually discussed this with the rest of
he
cabinet.
He has also threatened that he's going to be a presidential candidate. So Omar, the presidential aspirant.
So now we come back. So yes, now those are all questions to ask. Is he doing it as Mao the politician, Mao the aspirant, Mao the minister? And but now I've seen Stephen just shared with me shortly that he is set to introduce before cabinet now. And then if cabinet blesses it, they will now adopt it as the executive position and then move it to parliament. So now it gets interesting. We've seen all what those proposals are, to have special interest groups contesting for 2 terms, sitting for 2 terms and no more than that, using technology. But the one that is getting our eyes popping is, of course, having parliament to decide for us who leads us, and that means we will not have the power to exercise our democratic right as citizens. And I think that's the most unsettling for any any keen citizen. So I want you to first react to this before I come up with the question of now, how can the judiciary step in to actually help and guide the country? And I mean, there has to be sanity at some point in time. And interestingly, this is a lawyer, one of your own, pushing for these reforms. Your thoughts about these proposals?
Well, Judith, do we need electoral reforms? Yes, we do. In fact, some of the persistent issues in the elections we've seen since 2001, when even the Supreme Court pronounced itself, have not been addressed 20 years later, 25 years later. The issues of, because we've had 3 Supreme Court decisions on how elections are managed. I remember the last decision in 2016, the court even went further and ordered the Attorney General that you take these steps and come back and report to court, which even then the Attorney General didn't do within the specific timelines. So the issue of reforms is needed. In fact, it's even belated. When Honorable Mo was joining cabinet 2-3 years ago, it's one of the things he promised was going to be done the first 1 year. Because these reforms should be discussed extensively for people to get as much catch as possible. What we've always been seeing since 2001 is the amendments to the laws brought very close to the elections. If you look at the Presidential Elections Act, the Parliament Elections Act, they're all amended 6 months possibly before nomination, which is a hurried business, and it always doesn't augur well. Now, it's also important to note that sometimes the packaging can spoil each and everything, right? You've rightly said that now the selling point is that this is one of the things that is going to happen. Of course, we've not seen a physical, like you've said, that is the rightful process, the cabinet discussing, adopting it, and then they bring a bill to parliament. But now we just have Honorable Mao's oral statements. We've not seen a draft, we've not seen anything, just like Honorable Lumo as well. And of course, when one thing goes ahead of you, it can spoil the entire broth. Is it what we need most importantly, the election of the president by a particular electoral college? Actually, there are some parts of the world where it is done, but the biggest problem would be for Uganda is that the persistent issue since 2001, and I'm relating to 2001 because at least then we had a neutral arbiter court looking at the process, has been the independence of the Electoral Commission. Because when you have problems with the organizer, it's just like having a problem with a judge or a judicial officer or a referee in a football match. If one side thinks it doesn't matter what team you field the other side. So the key issue that I think we should be persistent on, because we've been having problems with the Electoral Commission organizing elections for the whole country. Just recently, President Museveni said 1 million of his votes were stolen. So it could be.
By you guys.
No, okay, by whoever. Although he hasn't yet gone to court. He was telling the thief to go to court instead of him. But the issue is, then what happens if you even have a smaller electoral college? So for me, I think the biggest issue is that the persistence has been the arbiter, the Electoral Commission. How independent is it to deliver a free and fair election? And we've not seen them do that. We've still had persistent problems in every election. The last election we saw security, the involvement of security, deciding who passes where, who should campaign where, and we're saying where is the organizer, where is the manager of elections, as the law says. So what would kill everything else is that if this body, which is supposed to be a neutral arbiter, has failed to organize, has had massive scale that even 1 million votes can be stolen under the president's watch, then what happens if they organize it when it's just 500 MPs? We've seen the involvement of money, the intimidation. So with 500 MPs, every person, a candidate will only need 300 MPs. You just need to either beat them up or bribe them or buy them, and then they vote. So for me, I don't think that is the biggest issue. The biggest issue is how do we clean up? We've not had a free and fair process, and the problem has not been because so many people are voting. It hasn't been because the manager has not been fully in charge, and that's what Honorable Mo should be preoccupied as he presents his views, and that's what we expect to come from cabinet.
Thank you. Marcy, let's hear from you.
I'll go back to the first issue I raised, that, and I want to base my views on the most important stakeholders in any conversation related to this country. And for me, it is Ugandans themselves. And so at all times, any representative speaking on behalf of Ugandans should demonstrate that they actually consulted Ugandans before presenting any views. As far as I'm concerned, we employ government officials. We pay taxes that sustain the state. And so I expect that the views and the opinions of Ugandans form the basis of any decision, any proposals, any recommendations for change of any form. And so when I looked at what was shared about what Mao is planning to table before cabinet, I asked myself what informed this. And as Council has rightfully said, there have been processes, legal processes in the courts that have had tangible outcomes, including recommendations for reforms within our electoral process. These have not been addressed. Neither have there been any efforts, for example, by the state to do consultations with Ugandans about their thoughts on these reforms, and therefore what would they want to see beyond the reforms proposed by the courts, what else, and then the commitment, the demonstrable commitment to address those issues before the next election cycle. But here we are, heaping new reforms and proposals on top of what remains unaddressed. And so are these proposals coming from Ugandans? That's the fundamental questions. Are Ugandans the ones that have decided that they would want to be governed a certain way? Because as far as I'm concerned, the Constitution opens with a bold statement about power being vested in the people of Uganda, who determine how they want to be governed. This is in our Constitution. Have the people in Uganda determined that this is how they now want to be governed? And that is why I said issues of justice, issues of the law, issues of the people cannot be detached. The people are at the center of any decision making at any level, whether it's in the judiciary, the legislature, or the executive. Because as far as I'm concerned, power can easily rest in the hands of any of these. If this country needed to be governed, it's between the three. If the executive falls void, power will rest either with the legislature or the judiciary to rule this country. And in doing so, Article 1 guides how the interests of Ugandans and their determination of how they want to be governed will sort of like show the way for whoever finds themselves in that position. So for me, it's not a question of the validity of what he puts. That's very important, and Council has extensively spoken about that. But I would like, just as a Ugandan, to ask if these views are coming from Ugandans themselves, and if they're not, then they are not in good faith.
Okay. Just a quick poll here. We are all of voting age. By show of hands, who wants their right to vote taken away from them? I don't.
I don't either.
I can conclude that no one in the studio, because
Your Worship, do you want that right taken away from you?
I am not supposed to speak.
Okay, but 3 out of 4, 75% of us say we want to have our right to vote. So I think that conversation actually has to really go down to ordinary citizens for them to actually understand how the implications of this law, of this proposal, should it actually sail through.
Exactly, and before it goes to cabinet.
Yes.
Which for me is the problem, because we cannot learn of something like this from the media, from rumors. It should be, if it's a good proposal, I believe that the right thing to do is to start with the citizens and then to say, having consulted extensively, this is the position of the citizens. Ugandans expressed A, B, C, D, and therefore we're now going to table it before cabinet for further discussion. That is the right thing to do. But if it is going to come from top to bottom, that goes to show you the place of the Ugandan citizens. And I think when we are discussing the role of the judiciary, that is where it comes. Because in a system like ours, and as is with other countries, people look to the judiciary as the space to resolve even political disputes, because many of these issues have legal implications, because the ability to dispense certain things are embedded in our laws, and the judiciary is the gatekeeper of the laws. So anytime there seems to be a departure from what is in the law, citizens will want to run to the courts to determine this dispute, which now appears to be between them and probably the proponents of certain things. And so that is where the critical role of the judiciary now becomes pronounced. And so the reason we want a sane judiciary, an independent judiciary, is because we know that is where we'll run should there be contest. They're seen as, the weighing scale for our society, because they're also in themselves a representation of our values, our diversity in terms of culture, age, religion, and whatever. The judiciary is a representation of all of that. So people are going to look to that. Yeah.
Okay. Your Worship, still on the issue of these reforms. Yesterday, during the Benedicto Chiwanuka Memorial Lecture, of course, there were issues raised about the independence of the 3 arms of government. I think that was by the Chief Justice. And of course, there are concerns that this is the time that, as a country, we should be seeing actually the 3 arms coming together and uniting and pushing forward like statements or speaking with one voice in regard to having a fair direction for like our democracy, upholding the rule of law, and so on. But we don't seem to hear the 3 arms speaking with a unified voice.
Well, thank you very much. I want, before I go to that, I want first of all to thank my sister here. She has ably given how the judiciary comes into this interplay when citizens would like to have redress. And if there are any issues, I want to inform the listenership that the judiciary is very ready to receive any issues or matters that need adjudication upon. We have the necessary manpower, we have the all facilities necessary to ensure that we listen to the citizens of this country. That's at that point when all these discussions are going on. We often are being accused of not doing anything. But, the judiciary is an independent arbiter when there is a dispute between persons. And like Mr. MCC and she herself has said, we have made pronouncements that will inform electoral reforms. We have done that. As a judiciary, in the separation of powers, we have done our part. So it is now necessary for those other players to ensure that they do. But if there is any issue, the judiciary is open to listen to our people. Now you are talking about speaking with one voice, and exactly that's what the Honorable Chief Justice was saying. He's saying that being an arm of government, okay, cannot work in isolation of the others two, okay, and working with the other two does not necessarily mean interference. It is exactly discussing, conversing, speaking, talking to the issues as managers of these different institutions. If the Honorable Chief Justice is seen speaking to the Speaker of Parliament, the public should not raise eyebrows, because it's healthy. If the Chief Justice is speaking to the President, who is the head of the executive, these are healthy conversations, because it is within those conversations that they are able to point issues to each other and say, there is this one not going on well, there's this one, please get back to our respective institutions, and we try to refine. Probably the question may be arising that are results coming out. We are very hopeful that what the Honorable Chief Justice has done, and as he voiced it yesterday, we expect results, and if anything is short of that, we shall have done our part. Ideally, we are really engaging in meaningful discussions. We have been accused of being interfered with simply because of those conversations. And we have had a whole debate trying to convince the citizens that, no, these debates are very healthy. For instance, how are we capable of getting some resources that are seeing us do so many things now in the judiciary? And if you visited the judiciary, you will see tremendous development, okay, and progress. We are moving in the right direction. Today, we are now speaking of how do we improve ICT usage, the virtual spaces, because we are moving into the industrial revolution, the fifth, okay? However, we cannot sit back, but we need resources so that we catch up. And we know very well that ICT is a catalyst for proper case management, reduction of corruption, because we remove the people-to-people interactions, you know. But we need these resources. So if the head of this institution, judiciary, cannot speak to Parliament and discuss these issues and also speak to the President and the executive, you can see how we end up being a family, but we are all in different bedrooms. We don't talk to each other. Where's the progress? The progress definitely will be lacking by and large. These conversations are healthy. We should allow the heads, and even emphasize that me speaking to either of these people has nothing to do with what my officers are going to do. He cannot be the Chief Justice and then he's calling a judge or he's calling a magistrate grade 1 that you decide this case in the other way or any other way. Even he made an example and he said no. He had to tell somebody, proceed, but you are going to act as a judicial officer. If you think it is right, proceed. If you think it's wrong, proceed. That is to emphasize that the discussions, which are very healthy within the arms of government, has nothing to do with the operational the judicial functions of the institution. So we are ready to ensure that we give the people of Uganda the justice that they need. As we are, and Mr. Msisi knows this one. Okay, when he comes to court, we listen to him, we listen to the other person as an independent arbiter, and we give a decision. Which decision, if it is not acceptable with misgivings, there is still a process, and we are also improving those processes, so that within a timely space, you are able to get a decision and justice.
I hear you. But what, in your opinion, do you think makes a lot of Ugandans not have much faith in the judiciary?
No, I think just because a lot of misinformation is given to them.
Like?
Okay, we have now a whole revolution. The online group. They speak a lot of wrong information, and you know our public now, they are the generation Z. Is it
Gen Z?
Gen Zs. Okay, they are 24/10 on, the internet, they are on X, they are on all these other social media platforms where we have not been.
So you should be meeting them there. They are. They have himself as an individual?
Yes.
But they do have a handle.
I am on X. Okay, I'm on X. And so when we pick them, and this is what we are doing, because we are finding that there is a lot of information which goes on about the judiciary. We are under the Registry of Communications and Public Relations. We pick this information and we are out there, we are explaining these things, and I want to assure you that we are gathering very good progress. Because now people are coming in to see the lies and the truths. Prior, we used to sit in our offices and chambers and we are just focusing on our work, okay? And the public does not know to what extent we are really doing the mandate that is entrusted to us. So today, under the registry, we come out, we are now telling the people, we are doing serious public relations and customer trainings, we are having so many court open days, we are having barazas, we are bringing the public now into the court environment and the courtroom itself, such that they actually get empowered to know. So that those lies, including those who take advantage of the ignorance here, can be worked away with.
Okay.
Exactly.
So, Your Worship, just one more thing. Like Council was saying earlier, when we see the proposals for electoral reforms, we're not seeing them now. The Judiciary has made pronouncements previously, I think 2016, on how to basically improve our electoral and democratic processes. But it's so many years, 9 years or even more, we don't seem to see a clear indication of where we are going as a country in terms of those pronouncements. And yes, we're hearing the Chief Justice saying you need a strong voice to speak as one across the three arms of government. But the question is then, does the judiciary just stop at making pronouncements? Can't it do more? And maybe at least as you collaborate with the other agencies, can't you push further to actually have these reforms taken up?
Of course, you will remember very well that in many of these judgments, these were recommendations to government. And you know, when you make a recommendation to someone, it is up to someone to pick these recommendations, okay? Because the court has listened to the issues brought before it and believes in and makes an obiter, okay, that I think this or this or this or this would have been better if it were done, okay, to avoid this and this.
Can't you set timelines within which those things should be done?
And these matters, as you rightly said, okay, were in a court case. The court cannot again own its own case, but there are parties involved. So that should these parties feel that there is something else they would wish the court to do, it would be the parties to come back to court and say, what do you say about this? So that the court can still make a pronouncement. It's like when you have a judgment and the court has given you relief and says, Ms. C is going to pay you, Mrs. is a rich man.
Make it minimum, maybe 100,000.
No.
You're discouraging me.
Okay, let us take 100,000. That's the judgment, the decretal sum. The court will have made that pronouncement, okay, in that decision. Now, if Mr. Msisi is not paying, okay, the other party who is a holder of the decree should come and tell court on issues of enforcement, and then the court will see whether it would be necessary to make an enforcement or use any other methods. Okay, so that's the situation we are in, that yes, we did our part, we made these pronouncements, recommendations to government, and that's how we can contribute in some of these kind of dispensations. Okay, so government, and I'm very sure the Attorney General is conversant with these recommendations. I cannot speak for them, neither do I know how far they have gone with them.
Because you've not been speaking as the three arms.
But now the conversations are on. It has been made official for the public to understand they are healthy, and we expect that, of course, the three heads of these institutions are also reading social media, they are reading all these kind of discussions going on. I'm certain they will come up with something.
Okay. do you want to say something? But before you say that, we've talked about the reforms. We've had your thoughts about these proposals. But I wanted you now to weigh in on just how then can the judiciary ensure it plays its role in safeguarding these fundamental principles of human rights and ensuring that these reforms build our society democratically?
Of course, the biggest need for all of us as Ugandans, as court users, what we need from the judiciary is independence. That's why earlier Mas was talking about how the three arms of government work. And most importantly, the judiciary is in such a unique nature that it's the neutral arbiter when I'm aggrieved by either these two arms. That's why it's so unique. And yes, I agree with his worship that, and just like the CJ said yesterday, there's no problem with the separation of powers. Doesn't necessarily work that you don't talk to each other. I see this even in politics sometimes, that people think that an ignorant person should not have lunch with
opposition.
Unless you are being seen as
you've been compromised.
Yes, being compromised. But the reason, at least from politics, the reason why people think like that is because maybe they know that there's a party which is known to compromise others, because it's very rare to think that if they see NUP and NRM to think that it's the NUP who is trying to compromise the other one. The chances are that they'll think that it's NRM which is trying to compromise. And I think that is the same analogy that they may tend to see, that they, because I don't want to imagine that if they saw a picture of the CJ and the president, they would think that maybe the CJ is trying to give a president a lecture on rule of law, that please respect this. They may imagine that it's the other way around. So, but indeed, there need to be cooperation and a healthy one, and also a check. As the cooperation should not be co-option. Now, the threats to the judiciary as the independence, of course, and the people who say that have been because of outside issues, the other two arms. They have seen the speeches of the president, and this doesn't go back to 1 year, 2 years, over time. For instance, he has a very, very opinionated, very strong views on bail. And he has not hidden his views on almost every opportunity that he gets. These courts should not be releasing. These courts should not be doing this. This court should not be doing this. And that's why people tend to think that actually, and even over in the past, we've also seen some strong statements from the legislature. Remember when a speaker described a court order as stupid? Never mind that the speaker is a seasoned lawyer. So those are threats, but then there are also other threats that go beyond. And for instance, people have been talking about the issues of appointments, because independence sometimes looks at how you are appointed, a statute of tenure, and then the financial remuneration to ensure that indeed you are firm in your position. So in terms of security, it's almost guaranteed. But now we have a problem. Another threat to independence is the issue of acting judicial officers. And I know, please don't ask His Worship's opinion about this, because it's a matter before court. But we have a court pronouncement, and some of us, like me, think that acting judicial officers in itself is a threat to the independence of the judiciary. Because just imagine myself appointed as an acting judicial officer.
You don't have that security of tenure.
And I'm told I'll be confirmed after 2 years, and I'm given all the perks that go with being a very huge car. And then after 2 years, you're told to go back to your to your chambers because please. So it's and then they bring Massey here, a strong anti-government activist, before me for bail. When my acting appointment is being reviewed the next 10 days. It would, even if no one tells me, it will turn my mind.
Yes.
Yeah, of course they are human. Judicial officers are human. So that is one of the reasons that why did they give this a strong statute of tenure, that you should decide cases before you without any fear from any issue. So those are some of the threats, and the Constitutional Court came out strongly and pronounced itself. Of course, we have a decision on appeal, but the state is continuing. So some of those threats to independence have been coming from outside, largely from outside, and some of them are structured from the law. Like, for instance, people have been agitating for more open, and I think even yesterday it came out at the bench, more open maybe appointments or vetting. And of course, we also have a pronouncement saying that it's okay that when His Worship here is appointed CJ and he has to come, and when he goes before Parliament, the process is like a popo election. It's behind the doors, and then we
you
don't
only
know
see smoke.
and then we wait. So there are calls that maybe that should be more transparent, involve the public more, because that's what the Constitution says anyway, that judicial power is derived from the people.
I'll hear from you, Master, but also there's a question that I'm just thinking of. Do you think that the choice of individuals to actually head these institutions could also undermine public trust? If, for instance, you have an individual who is scandal-ridden or is always in the news for all the wrong reasons, whether it's graft or things like that, and then you are meeting you're seen to be meeting this individual who actually has so many question marks about them. Does the character of the individual, in your opinion, actually contribute to this lack of trust that people... Yes.
I think for me, the trust is built in... and trust is both ways, both from the judicial officer and from the public. And if we work on the structural issues, for me, I don't think we'd have a problem with the issue of the individual. Let me give an example. There have been judges who have been appointed when they've been political actors before, open political actors, and they went on to do their judicial oath very, very ably and competently. The current CJ was a minister. His predecessor was a minister in this government. Justice Oscar Chihika, whom I highly respect, is a former director of NRM Affairs. There are not very many people who would think that he's incompetent. So the issue is, if the person is right and the appointment is done rightly and there's involvement, there wouldn't be people thinking that that individual will have issues. If the the process is not, and then I know that there may be judicial officers who may be appointed, and many lawyers will say, "Oh, you'll hardly find a lawyer." I'm talking about lawyers who are, because they're regular court users, but even the public, I can't even say the public, where the public will say that they would have no problem. They would say almost consensus that that is the right fit. And then there was one where there would be almost general consensus that, wow,
no.
how did this person end up here? So you only rectify that by working on the process. How do they get there? How do they get there? And I think if you do that, then you get the rightful people. And for me, I think that is also representative of what the people should have on the issue of the trust that you're talking about.
So, in a sense, if the institution and the processes are strong enough, then they should be able to check the excesses of the individual and put that individual to order. Thank you. Mercy, let's hear from you. How can the judiciary actually help in safeguarding these fundamental principles of human rights and to just ensure that our democratic process is strong enough?
Yeah, as I said that we all know that the judiciary itself is the mirror of society. And in the state in which we are, they stand in between the people, the law, the ones that rule over the people. And so going back to the fundamentals of why the judiciary was established in the first place, you know, the concept of separation of powers and the rule of law is very important, and for us not to lose sight of it. And it's actually in the best interest of the judiciary itself to ensure that they are seen as that image is constantly what the society sees, because that is what will build public confidence in the judicial system. I'll just give an example of what has been happening in Kenya during the protests and, you know, the contest between majorly Parliament, the executive, and the citizens. In that situation and confusion, it has been the judiciary that has constantly, independently made decisions, some for and some against the proposals of citizens. But in doing so, they have applied themselves to the safeguards in the law, ensuring that either side does not breach the law or go beyond the confines of the law. And I think that is what gives citizens the confidence to keep going back to the judiciary. But of course, we also know that, for example, one of the fundamentals that the judicial system is established on is that of inclusion, and inclusion broadly in terms of the structure of the judiciary itself being inclusive in how it is composed, in its systems, laws, processes, and some of the things that Council talked about, including, you know, the tenure, the security of job of the judicial officers, their own security, personal security as well. We've seen again in Kenya recently how a magistrate was shot after she had adjudicated over a matter. We saw just last week or the other week where the security detail of a judge was withdrawn because they made a decision against the office of the IGP in Kenya. But I also saw the judiciary standing strong and firm to defend
their own,
making a bold statement and putting the state in a position where they had to defend themselves and restore, because they know that this is a right for them. So when I speak about inclusivity in structures, in systems, it does not abdicate the judiciary as a structure, that they should have the resources, they should have the capacity to deliver what we expect of them. And so that means there has to be significant investment in that as a structure to do what they have to do. But on the other side, within the judiciary, that the rules, the laws, and whatever is needed for them to dispense justice should be there and should be robust. But also that in doing so, they should continuously promote inclusion. Being inclusive and promoting it are two different things, because promoting it then means actively taking steps to ensure that they check if the judicial system is actually being inclusive. So because as we again go forward, the context keeps changing. It's very fluid. Issues around, the advent of the digital tools, issues around, things like disability and different things. Our courts were built back in that day when the context was very different, but now
times have evolved. Yeah.
So you're walking up to maybe Uganda Road Court and you're wondering, for a litigant who is disabled, or how do they walk up to the courtroom? Is there assistance? Are there facilities that will enable them go up there? The language of the courts, the accessibility, even if I was going to receive a judgment against me, as long as the court environment is one that allows me to understand that I have been listened to, that the system is inclusive of my
needs, it caters for all your needs.
I'll leave knowing that justice has actually been served. And also, of course, the judicialization of politics, which is people looking at the judiciary as
the politicization of the judiciary.
Yes. That is something that, of course, the judiciary will grapple with for a long time. As I said, where our governance system is also determines how people perceive all systems. That's why we're very intolerant of each other. That I cannot sit with an NRM person without being labeled this. I cannot talk to a person, me now from civil society, if I was seen talking to maybe Honorable Chagulanyi, I would be looked at as
pro NUP.
Yes. And then if I'm seen with
NRM, then you are pro NRM.
And then tomorrow, if I'm with NRM, it will be, you are sell out now to this. So
yes.
So you find that you are, the environment dictates how people perceive you, but it's also our duty in the way we work, in the way we make decisions, to steer clear of those kinds of perceptions. If you're going to make decisions on a political matter, let the decisions be made according to the law. We should not be seen to be furthering the interests of those who want to use these systems and structures as political tools. We should stay away from that and let the courts be sane. Let them make their decisions independently, so that whether it's for or against, people can see that it is just. I've been in a couple of political cases this past 1 or 2 months, and I must say, as far as I have seen, especially from the last one, you could see that the judicial officers in these matters were straight to the point and made decisions that I would think are fair, based on the nature of offense and the need not to, crowd the court the more or the prisons the more. And yet our expectations going to the courts were different, but what we came out with were different as well. And I think for me it gave me such joy, because I've been in this system for a while. It gave me such joy that in this moment the conversations we were having were quite different after that. So, and I'm not saying that they should always go that way, but what I'm saying is that if you stick by the law and you apply the law as it should be, nobody's going to complain of unfairness. And these are some of the things that make people start decolonizing their mind from the thought that the courts are being used. And that is not something that I would say is not true. It is true for some. There are elements that can easily be used. Nobody is immune to influence, external influence, because when we go to seek justice, you want it to be in your favor.
Of course.
And so there are going to be attempts. There are going to be attempts. There are going to be investments in people, in structures to ensure that the purpose of justice is defeated. So we cannot say that our judicial system is immune of those influences. It is actually, to a larger extent, infiltrated. But that we cannot also say it is fully, because we also see sections of the judiciary that remain sane. And so we need to move towards having the judiciary as an independent system by its structures, systems, policies, and the extent to which it is inclusive in how it administers.
Thank you. So there's
a very quick one to what Master is saying. I entirely agree, and I'm saying that the biggest power of the judiciary is the trust we have in them.
True.
The thinking that this judicial officer is
trustworthy,
irrespective of what comes out. Because and sometimes perceptions are also important. Sometimes perceptions are wrong, but they're also key.
That's why I was asking about the character of the individual and how people perceive.
Because if a person gets a judgment, even if it's against them, if they believe that the person is fair, they'll
accept graciously. Yes.
Even if the persons don't have trust in the judicial officer, even if indeed they would lose before any other judicial officer, they would have every reason. So it's key that we protect that trust and we remove the tentacles that we can. And of course, some of them are for people like us. His worship cannot. Some of them are for people like us to talk about them. These tentacles sometimes are outside.
There's I don't know if it's a question or a comment directed at you here, but it came through, Stephen, that asked us in 2017 during the debate on Article 102B of the Constitution against lifting the presidential age limit. Some Ugandans spoke, of course, against this law, against the proposals to lift the age limit from 75. But some MPs or ministers went against the voices of their electorate and actually voted yes. They lost the 2021 vote. So they're saying that could mean that if the electorate vote the MP, then that very MP could still represent, or definitely the MP represents the electorate. And if, for instance, we have this law to say have the parliament choose who the next president is, then the MPs can still go against the electorate in this case.
Of course, and that's the danger. That's why I really want to emphasize that all power belongs to the people of Uganda, and the people of Uganda have every right to determine how they want to be governed. If they wake up and say this is how we now want to be governed, that should be respected in a true democracy. And so my problem with the conversations we've been having this week is that it is a top-bottom approach. It should be a bottom-up approach. And that has been the same thing, especially with the legislature and the executive. Even for certain contentious laws and proposals, many times you find a law emanates from Parliament, it gathers public opinions, it becomes a contested law, then the Parliament decides, okay, now go and first consult with the people.
Consulting after the law has... they should have
when
started.
There's really a contestation. And so people, they'll give you maybe 5 days, they'll give you 5 million to go and
not adequate,
consult.
yes.
And so whatever the MP comes up with is not backed by evidence. But if we actually invested more in... of course, I also say this knowing that there's no interest in investing, but the most important thing to do would have been to get the views and opinions of the people about how they want to be governed. Whether they agree with such positions or whatever, let it come from them so that you can speak with confidence that this is the opinion. It's not hard to see what Ugandans want. In this country, unlike many countries I've been in, Ugandans are very expressive people. It's very easy to tell, even if you're in a village, you can tell that Ugandans have the basic
But Mercy,
ways
you
through
are
which they express
assuming
how
that
they
these
feel.
policies or laws are actually passed in the interest of the citizens.
No, they are not.
But exactly.
Because
So-
they are not consulted, so you cannot. And for me, if, for example, this proposal, it can go through, but it will not represent the views of the people, because there is no evidence from Norbert Mao that this is, Ugandans have decided that
This is what
following
they
A,
want.
B, C, D, because we want to understand why.
Why are we
the
arriving at this
proposal?
conclusion? Yes.
What's the basis? There has to be a basis. You don't propose something without a basis, and then you're going to have an MP represent my views when I did not first of all ask that you change anything. Are Ugandans tired of the laws?
lining up and
because I
and
know before
voting?
the 1995 constitution was written, the proponents of that law moved the entire country.
Yes.
There is evidence to those consultations, what Ugandans said. That's why its basis is the culture, the norms and aspirations of our people. Because there is evidence. Those who lived at the time this was being done can attest. I have had interactions with many of them. I've worked with many of them who will tell you, we went to West Nile, we went to Acholi.
It was
we went to this place.
consultative.
So
It was
consultative. And so if you are going to depart from that, you must go back to the people. Maybe generations have changed. Maybe views have changed. Maybe cultures have shifted. But that should be the norm, so that it is documented that it represents the aspirations of the people who now want to be governed this way.
Thank you. Thank you very much. Stephen is showing me that it's time for us to take a break, and we'll go for a break right now, and then VPN returns, and we'll continue with the conversation. Welcome back. And thank you for keeping it with us here on VPN on 933 KFM. My name is Judith Atim, and I am here joined by His Worship James Eremi Mawanda, the Public Relations Officer of the Judiciary, Master Grace Manduru, Governance Expert and Head of Programs at Action Aid International Uganda, as well as Counsel George Musisi, Human Rights Lawyer and Partner at Pace Advocates. We are looking at the justice sector, and we're asking how to position the judiciary for a just society. Before we took the break, we were talking to you, Mercy, and I think we're actually done we were talking about Article 102 and the implications, basically drawing parallels with these proposals and what the outcomes could actually look like. Now, we want to talk about the conduct of the judiciary when it comes to executing their duties and exercising their freedom. We're looking at the example of the Supreme Court Judge Esther Kisache in 2022 when she sued some top brass of the judiciary citing mistreatment before she asked for early retirement, which was rejected by the president. Your Worship, I don't know if you could just bring us to speed with the latest from the Supreme Court bench, whether Justice Esther is still on the bench. Is that something you're comfortable to discuss?
No, as far as judiciary is concerned, she's still with us. Yes.
Okay. And also, could you speak about, of course, the independence of the judiciary? I know we've been going round and round discussing this, but I mean, if you still have challenges like this cited by Justice Esther, how, if you're having these kinds of challenges at that high level of the judiciary, these are people that the society looks up to with so much respect and admiration. But when we hear these kinds of tension and conflict at that level, we as citizens also have certain perceptions that also make us question to what extent is the judiciary independent. If this can happen to people of that caliber, then what does it mean to access justice for an ordinary, lowly citizen like me and many others out there?
I didn't understand what challenges you are talking about.
Broadly speaking.
But what I know is that Justice Kisache is a citizen of this country. And if she has an issue and she would love that the issue should be adjudicated upon, she has that right. And she exercised the same right. Okay? So I don't see what people are saying. I don't know why. But it's important for them to be educated to appreciate that where there is a contestation you will always see those emotions coming through, and of course bystanders will always have their perceptions of it. What is the judiciary's role here is to ensure that we instill that confidence back into the people, and that's what we are broadly doing. The judiciary is an independent habit, and it doesn't matter whether you are a member of the judiciary yourself. If you have a matter before a court, we have had judges who have had cases in court and they have lost them. You see, we have had so many other people still. So as long as there is a matter in the court, you will definitely have all those emotions. And depending on how each party wants to buy the public sympathy, there will be a lot of things that will come out. We as a judiciary, we want to remain focused to ensure that at all times we give the public and the parties involved in the matter the due process that they require. In other aspects, what we are doing as a judiciary is to ensure that we robustly, improve on our public relations and customer care. And this we are doing it so much in most of all these regions of this country, including the center. Last year we had the National Court Open Day, and we look forward to having another National Court Open Day, and then also regional court open days, where the public will come in and we get feedback. It's a forum for public accountability. It's a conversation we want to have with the public, where candidly we want them to tell us. And we are gathering a lot of views whenever we are on these court open days. We gather views which we bring back on the table for discussion and say, no, this is ABCD, this cannot continue, this cannot continue. We are also improving seriously on customer care. Trainings are going on every quarter. We have more than 4 trainings on customer care in different courts, to ensure that our officers, judicial officers and support staff are up to date with customer care issues. We are dealing with human beings, and these are human beings which come from the public itself.
With different upbringings.
They have
and
a lot of these kind of things. You get a point? So we have, and I'm happy when Masa said that, yes, a good crop of us, and I hope she also included me. Yes, we are really up to the task. That's why Mr. Musisi was just shy to say, I'm one of those who made it to be appointed the judge of the... Am I right, Mr. Musisi?
Congratulations.
You see? So we have very good members of the judiciary, judicial officers who are perfectly doing a good job.
I actually know some.
Yes, but as you notice, we are human beings. We have others who have individual weaknesses, and we are addressing them. We have so many interventions that have come in. We have we are now working on strengthening the inspectorate. Inspectorate of courts, where we even want to do now, with resources available, have regional inspectorates who are going to check on situations like that. Under customer care, for instance, the example Mr. Musisi was telling us about here in the break, that occasionally you would see litigants at courts unattended to. That is now an issue of the past, because we have now customer care officers at those different courts, and we have scaled them to ensure that every litigant who comes to our courts is attended to at the entry point and is processed through to their last end, until again when they get out of the court. That we believe...
So that's being done across the country?
Yes. And we do review trainings, to go back where we have done a customer care training. After a few weeks or months, we go back for court open day. You see, because we want to
get feedback from the public. What's working and what's not working.
Yes, so that we are able to say, you see, we came and trained you here. After this period, we have a court open day, and the public are saying this thing where we even trained you, has continued to. So we know where now to attack, who to talk to, who to...
How to plug in the gaps.
How to plan those gaps, etc. Now, in the public relations, we do also communications. Let me tell you, if you have noticed of late, we are now all over the airwaves. What are we doing? We are ensuring that we sensitize the public about court processes. All of these things, there are also
actually, we need to have another conversation on that another time. Yeah,
the people have lost, as Master said, confidence in the judiciary because they have no information. And those with information are taking advantage of the public. You get the point? So at the end of the day, the public thinks whatever happens around the court is because of the judiciary. Whereas we have all these masqueraders around. And so what have we done to ensure that we do public sensitization? Now it's a deliberate step to ensuring that when we demystify those processes so that people understand them, the middlemen, the purported middlemen, the bush lawyers, okay, the cousins of Mr. Musisi, they don't take advantage. Do you know that even in the bar we have those wrong elements? Okay?
Yeah.
Yesterday we had the bar bench. One of their members said they are thieves. You see?
They are thieves on the bench.
Said, yes, on the bar. He also alluded to the bench, which we said, well, it's good you have those examples. Can you come and share with us so that we can investigate these things? What are we doing is to ensure we clean. I am happy for those who are doing a good job, but we are also moving towards those who are not doing a good job to ensure that at the end of the day we achieve a good public image.
So during your open days, the feedback on corruption, what is it like from the public?
Oh, incidentally, it has clearly now come out that there is perceived corruption, which is as a result of sheer lack of information and also knowledge about court processes. But we have also come to appreciate that they are all the actual purported corruption, okay, in the videos and where information has brought, as you have seen, people have been prosecuted, you see, our own. But we have now that other crop. And we have asked all other players like the police, the IGG, to help us. Okay, there are these masqueraders around courts.
Yeah.
In fact,
middlemen. There are so many. They're brokers.
The majority of cases involving extortions of money and all of that corruption, okay, are middlemen. And so we have asked our judicial officers to be on the alert. We have asked the police to help us. As soon as we get one of them, we want to arrest and prosecute them. We need to have examples. We have even gone to the other level, and we are telling the public, there is no corruption if there is no giver. And the offense does not only look at the receiver, it also looks at the giver. And we are telling the public, please, we are going to arrest the public who are giving this corruption. We want to arrest some 3, 4, 5
as examples.
Prosecute them also.
Thank you, Your Worship. Right. Stephen tells me it's time for us to take a break, and then we'll be back and pick some few calls to just hear what our listeners have to say or the questions they have to ask. We'll be back shortly. Welcome back. This is still VPN here at 933 KFM. Very interesting conversations we're having here. We've talked about the issues of Justice Esther Kisachi, and Your Worship actually made, we had your submission, but Counsel Musisi, this is actually for you, that His Worship may say that Justice Esther is part of the bench, but that doesn't mean the issues she raised are not happening or that all is well. Of course, if you read that story, there's so much that has actually been going on that she actually talked about. There were money issues that were raised. She wanted, of course, a permanent injunction against the Chief Justice and 5 others. So she wanted them restrained from withholding funds withdrawn from the consolidated fund and refusing to pay her salary and other allowances without following due process. Just the background, if you're listening and you wanted to just to have a reminder to check your memory a little bit. So, Musisi, these issues...
Hello?
There's a caller already.
Yeah,
okay.
Juma is on.
Juma, is that you?
Yes, I'm the one. How are you?
Yes. Good morning.
Good morning to you. How are you? I'm greeting to all the journalists with you there.
They've heard your greetings. They're smiling.
And our producer also as well. Don't leave our producer behind.
Oh, our producer, yes, he's also there.
No, now, for me, you see, me as when I eat,
what
I demand is all a service delivery. of accountability. Whoever found guilty, action to be taken. I need it to be at the cameras that this officer has misbehaved or the conduct ethic. So for me, I want to be.
Juma, can you slow down a little bit because I'm not understanding you very well.
Okay. Are we together now?
Yes.
Okay. Me, I was saying the public are for service deliveries. Okay? No matter whether it's in uniform of army or uniform of police, we need service deliveries. Another thing we need the conduct of those forces. Sometimes they go past their ethic of work. Even if I find who is off duty, is he going to connive with the citizen outside there? They are doing silly things there because he has that title that is a scary, is a fundy.
Okay, Juma, we are talking about the judiciary. Do you have any comment regarding the issues we've been discussing concerning the judiciary?
Yes, I have.
Yes.
Delays of court and in terms of investigation, the CIDs, they are sleeping on jobs.
Mm-hmm.
There are some cases which need their attention with immediate effect.
Mm-hmm.
But they are being compromised in the long run.
Mm-hmm.
And they are so proud in their offices. This judiciary, when you go to court, sometimes you sit outside at the veranda there has a client for them, and some of them holding file at their waist. They look at you like you are already a criminal. We need that customer care. This gentleman was talking about. We need the customer care ability or the customer care to be lectured proper how to be a good customer care.
Thank you very much, Juma. Hello? Okay, Judge, let's come to you as we wait for other callers.
Of course, I earlier mentioned that the biggest strength of the judiciary is the image.
Mm-hmm.
And that's why some of us who have a strong passion for an independent and strong judiciary, no one would cheer on when the image of the judiciary is being drawn in the mud, because we all need the judiciary at one point or the other. And I even argued then, like I still believe now, that those issues, whichever issues just raised, would better be resolved by a sit down behind closed doors, for purposes of not dragging the entire. Because she was putting the judiciary in a very tight spot. That here is a sitting judge of the Supreme Court. Leave alone the comments, but she went to court. and the respondents in our constitutional matter included individuals who now just imagine if this matter was to be decided and then it goes on appeal, it goes before a bench where she's a member, where the Chief Justice is a member as well, who is supposed to preside over. So it even presents legal issues. Mm-hmm. So that's why I said that
we have a caller. Sorry, Judge.
Yes, the most important issue would have been to address the causes, especially, if at all, behind closed doors, for purposes of not having the public drag the patient.
Hello.
Okay. We have a caller. Yes.
Yes, hello. Good day.
Yes, good morning. May I know who I'm talking to, please?
I'm so delighted. This is God Willis Izo.
Yes, God Willis.
Yes, I'm so delighted. One time when we were discussing this issue of trust on the judiciary, and I'm so negative because I lost the land just because of the court itself, because they gave the land to the person who have the money. Me, who is poor, who had no money, I lost the case. So, and the people they enjoy in my land. So I did not have trust from that time up to date.
Mm-hmm. Well, thank you for you. Another caller. Hello.
Hello.
Yes, please.
Good morning.
Good morning.
How are you?
Fine, thank you. May I know who I'm talking to?
Richard is my name.
Yes, Richard. Thank you for calling.
There are some few questions that I need to pass across. My first inquiry goes like this. There are cases that have taken time from 2019 up to date. Those cases have been in court. have not yet settled up to now. Another question.
So what's your question? Cases from 2019 to date, they've not yet been settled. You want to know how long it should take for a case to be disposed of?
Then secondly, after cross-examining someone, how long should the judgment be given to someone? Because there are some cases that have taken a year plus without someone receiving his judgment. What does it mean?
Thank you very much, Richard. Okay, I think we can stop it there for now. Yes, Judge, you were still talking.
Yes.
One more caller? No. One more? Okay, yes, hello.
Yes, good morning, Judy.
Yes, good morning.
I'm Ayuku George in Entebbe.
Yes, George.
Yeah, here in Central, I've seen courts that are sitting every day, almost every weekday.
In Entebbe?
Yes, and Central region. But up country, especially Western Isle, it's rare to have court cases had every day. I don't know why. So what could be the problem? Especially in Massa, where I come from, we don't have a magistrate court. So people have to travel all the way to Koboko or Arua to have their cases heard. What could be the problem?
Okay. Thank you very much. Okay, I think we now have the platform. George, let's first finish up with...
I was replying to the issue of the questions of Justice Society,
yes.
and I was saying that those issues, whichever issues that were raised, because they have a key bearing on the image of the judiciary, they would have but and I knew that there were efforts which were being done to resolve. I don't know how successful or far they are, but I think for purposes of the image of the judiciary, which is the general public is interested in, some of those issues were better resolved behind the scenes, and then I don't think it's even needed those possibly going to court or the recommendation for appoint for removal on. But want to imagine that maybe the lull is for purposes of settling whatever issues that had arose. Yes.
Okay. So I don't know if you guys could now respond or comment on the calls that came through. Joma says public wants accountability. He says the judiciary, well, we need good customer care, like your worship has been saying. Some of these judicial officers are proud in their offices. Well, these are perceptions from ordinary citizens. Godwill says he has a negative perception about the judiciary because of a case he lost. It was a land dispute, and his thinking is that he lost because the other party had more money to actually pay for the case, and so on. Richard says cases from 2019 to date are in court. They're not yet settled. How long should it take? And after cross-examination, how long should it take for judgment to be delivered? George says courts sit almost every day here in central Uganda, but in West Nile, this doesn't happen. What could be the problem? People have to travel long distances to access justice.
Self-appointed
president of
I think you could start with
that. Those are my constituents.
Yes, yes.
My citizens. As in, we there's a lot of them.
I only know me. That's the part I know.
No, I mean, yeah, I'm very happy. I'm always happy when people from all walks of life, this is the power of the media, that we're responding to problems somebody's facing in Arua or Maracha on KFM here. Where we are today. I think that it just goes back to the point I said about the judiciary being seen as the face of fairness and a place where people also go and, receive justice. But the judiciary is also a teacher, in my opinion, because part of their fundamental roles is to ensure that the users of that system have the capacity to use it. So whether it's through legal awareness, whether it's through, community engagements, taking the court to the communities where communities are able to appreciate the system, explaining concepts like backlog, for example, because it is the backlog that makes people even more and more bent to believe the fact that it is because of corruption. There's no justice, and there's, of course there's corruption. That we cannot take away. There's corruption in the justice system. However, I also know that case backlog really compromises the ability to timely dispense justice, and I really hope that one of the things Judiciary commits to do is to reduce the case backlog in the courts, because that is partly what will build confidence.
Exactly.
Sometime I remember when I was working at FIDA, we partnered with the Judiciary to do special court sessions for section gender-based violence cases, and we reduced the backlog significantly by over 60% in that short time, where the courts were just committed to dispense. And before the sessions, we had a lot of engagements with community, explained to them, made sure police had their people ready and things like that. And by the time we ended that 1 month, there was a significant reduction, because those cases coincidentally made the biggest proportion of cases that were backlogged. So we need to invest more in timely dispensation of justice, of course not compromising the principles of fairness, and ensuring that even in doing so, that justice is still upheld in how decisions are made. So it's about being deliberate and ensuring that Judiciary has the capacity, but also invest in the capacity of the users to understand the system and interact with it in a more inclusive manner. So
this is something actually I forgot. We should have had this discussion at some point in time. This front page of the Saturday Monitor says new police boss, same old issues. Money wars. Figures for from 3 financial years show a decline in funding to the police by 20.4%. So a report indicates that the defunding of the Uganda Police Force has affected even the basic services like clothing, accommodation, and welfare of the officers. And if you have a hungry officer, school fees is looming, he's living in poor conditions, he has one pair of uniform which is also getting worn out, and there's no provision for him to get another set of uniforms. Are we not creating opportunities or weaknesses or loopholes for our police officers to actually engage in corrupt tendencies, Your Worship? Because this is our first point of contact with the Judiciary.
Well, I can only say that the situation there can impact, on the justice delivery at all those centers. Like you have heard Richard say about his, was it Richard or is it, no, it was Juma.
Juma, yeah.
Who was talking about police, army, that when you go, the CIDs...
They're sleeping on the job, they're being compromised, yes.
It's an element that can affect morale, and I want to think that the police should be able to take it up, and government to ensure that that does not happen. Of course, you see, the Judiciary is at the receiving end. Everything is processed by other agencies until the Judiciary, and if the quality of work done by other actors is poor, it's oftentimes going to be, the result will also be wrong, at the end of the day. And that explains probably why Mr. God Willis is having misgivings. For him, he says he lost a case because he thinks it was money. It's very unfortunate, because that is the perception he has. But we are doing a lot of public sensitization to ensure that, yes, you may lose a case at the first instance, but we have available remedies to a person who has a dissatisfaction with the court decision. And we are telling the public, don't lose hope if you have lost a matter at the first instance. For as long as you are dissatisfied and you have good grounds, you get to the next level. And that system helps to ensure that we give justice to our people.
Thank you. In 30 seconds, George, let's hear from you and we just call it a wrap.
Well, I think we just have to go back to what we call the constitutional requirement, and it's of judicial power being derived from the people and to be done in accordance with their aspirations, and how the judiciary interprets that. In fact, I was very glad when the theme of the day which was celebrated yesterday was a people-centered, and of course His Worship here has a very, very hard job of deriving that, because of course these are individual judicial officers, and of course the judicial officers is independent from each and every person. How do they appreciate?
It's time up.
How do they appreciate that what I'm doing should be in accordance with people's aspirations?
Yes,
and it's a hard task.
Thank you very much to my panelists, His Worship James Remy Mawanda, Mercy Grace Munduru, and Councillor George Musisi. Thank you very much for your time and your insights on the conversation of the justice sector and positioning the judiciary for a just society. My name is Judith Atim, your host. This is VPN. We'll be back next Saturday, same time. Do join us then. For now, have yourselves a pleasant weekend.